Welcome back. Um, so our topic for the next hour or so will be IP laws. IP meaning intellectual property. So before we dive into that, how many of you are familiar with intellectual property rights to some extent and what that might cover? Any of you, have you come across intellectual property rights? What intellectual property rights include? No, not at all. You have, of course. Anyone else? Sorry? Stealing, yeah, okay. Yeah, stealing your ideas. But, okay, okay. So you've already forgotten. Uh, and you were just doing an assignment on patent rights and so on, right? That's what Dr. Janet just mentioned. Okay, so intellectual property rights, you've all already just had a session, but basically we talk about copyrights, patents, trademarks, trade names, trade secrets, all of those are kinds of intellectual property. So you've already, so I won't go into sort of an overview of what is intellectual property, right? Again, if that's what you already covered in the last talk. Instead, we'll talk a little bit about copyright in particular and copyright law in India. Copyright, as the name suggests, is the rights that you have over your own copy, right? Your own material that you have drafted, that you have authored. Whether that's a paper that you write to submit in a course, or a book that you write, or a novel that you write, or a research presentation that you submit, or your PhD thesis, or your master's thesis. All of those are materials that are authored by you. And so you have copyright on that material. Any material that is original, new, authored by you, and original doesn't have to mean 100% original. None of our thoughts, or very few of our thoughts, are all 100% original. We learn from what we read, we learn from what we hear, and we sort of use that to put our own additional thoughts together. But that additional thought is unique, and to the extent that it is not just a copy of something else, you have copyright over that because it's your own work. So that's a traditional copyright, right? And that can be over obviously writings, but it can also be over other works. And what that means is it can be over art. If you draw something, then you have copyright over that drawing. You paint something, you have copyright over that. Similarly, you can extend it to programming. You write a program, a computer program, you can have copyright over that because that is some unique different work that you have done, which is not simply a copy of something else. Now, what does it mean to have copyright over something? Sorry, you had a question? No. Okay. What does it mean to have copyright over something? So, what it means is you, as the author of the material, have the right to give someone else the right to copy it, or to disseminate it, to distribute it, or to modify it. And only you have that right, because this, whatever material that you have copyright over, you are its owner. So you can decide how it is used. You can decide to not show it to anybody, keep it for yourself, show it only to one or two people close to you, or you can decide to publish it into a book, sell that book. Why are you able to sell that book? And obviously if people want to buy the book, they'll pay for it. Why do they pay you? Because it's your work, right? So you can decide to distribute it, disseminate it, publish it, and someone else then cannot take that book and then publish another 100 copies of that book and then distribute it. Because then you are not getting the royalty or the money for having published that book, right? So that's the right that you have as an author. You have the right to control how that work is used. And that applies to whatever you have copyright over. Again, as we said, it could be books, it could be anything in writing, it could be poems, or it could be programs or code that you develop and write. Right? When you work for a company or work for the university or do some research for the university, there's often an agreement that you may or may not recall signing that says the work that you do, whether it's a research paper or a code that you write or whatever, you are assigning that copyright to the university, to your employer, whoever it is, right? So, because they are paying you a salary every month, or they are doing, if you're a research assistant, they are giving you a research stipend, whatever. They are paying you already. In exchange, often institutions like universities or companies that you work for, what they will do is, because you're being paid to do that work, whatever you produce, you're assigning the copyright over to them. Okay, so you're giving away your right to them. You could, if you were a, individual inventor or something like that, you could say, no, I am not giving away my copyright over things that I produce to the company that I work for. Instead, I am going to negotiate that whatever I do outside of my work, for example, is mine. And that is usually the case. If you are not doing something as part of your employment, but you are, say, doing something on the side outside, the copyright in that belongs to you. So, for example, the copyright on these slides, the particular slides that I make, belong to me. I can decide whether I use it here, I can decide whether I use it somewhere else, I can decide once we put it up on the GIAN folder though, then that's going to be distributed. But then somebody else, let's say you decide to go give a course on copyright, you can't just take these slides and go present them. I mean, you can, but that would be a violation of copyright, right, of my copyright. And for copyright, one of the interesting things is, you don't have to do anything more apart from just having written the document itself or created the document. Nothing more. As soon as the document is written, completed, or whether incomplete, however it is, as soon as you have put it down somewhere in some form of writing, or whether it's writing on a computer or writing on paper, whatever, as long as it's reproduced in some manner somewhere, you automatically have copyright over it. Nothing more needs to be done. The law does, of course, say that you can do something else to let the rest of the world know that you have the copyright over that thing, over your product, right? So if I just wrote a book on copyright, and I just kept it to myself, or published 10 copies and gave it to a few people, I still have copyright over that book, but the rest of the world doesn't necessarily know that I have copyright. So I can go and have that copyright registered. There is a manner in which the government says you can go to the copyright board. There is a board in India, and you can go and submit your work and say, this work was authored by me on such and such date, or it was completed on such and such date, and therefore I am registering that this is my copyright. How does that help you? It helps you later if you find the same book, all of the same material, or one chapter exactly taken and put into some other book and somebody else is selling it, right? You can then take them to court and say, this is a violation of my copyright. Without my permission, he has copied the work that belongs to me, and he or she is now selling it for profit or whatever. Right? So you can now, it's easier to demonstrate, to prove that you have copyright over that material because you see I have this registration on such and such date. But do you have to do it? No. Most people, in fact, unless you are a famous author, publisher, writer, painter, typically they, one-off individuals who just write books or stories or novels, whatever, don't get their copyright registered. Instead, because they already have the copyright, they'll just rely on that. The first time they publish a book, for instance, they'll say, this is evidence of the fact that I wrote this book, the fact that I got this book published, and see, that's all you really need. I mean, it's just a little more, it just needs a little more work to show that that was your work originally.
So it is not enough to put copyright symbol the first page or something, you still have to sort of register?
You don't have to. It is enough to put a copyright symbol. So the copyright symbol is just a C in a circle. You might have seen that. It's enough to do that. That is simply, again, sort of you saying, I have copyright over this. And you can do that even without going to the board and having that formally registered. The formal registration just is a step that is nice to do if you anticipate that there is going to be a copyright violation, or even if you don't anticipate it, it just makes it easier when you go to court. Instead of now having to prove in court that this in fact is my book, this in fact was published before that person published his book, for example, right? If he's taken a chapter from your book and published his own book, then he may say, no, I wrote it first. Let's say the first date of publication of that guy's book was 5 days after yours, right? You had it, you already had it written in your, on your laptop, but you just never got it published. Just because it's not published doesn't mean you don't have copyright over your work. You still have copyright over your work. Let's say the publisher, you went back and forth, and you were discussing what's the picture that's going to be on the cover page. That took 3 months. And so the date that your book got published was 1 month after his book got published. But somehow he got a copy of what you had written on your laptop because you had sent it to 2 friends who you thought were friends. One of them loved that one chapter, took it and published his own book, right? So in that case, even if you're going back and forth with the publisher, you might want to go and get your copyright registered just to say, yep, I had my copyright registered way before. I mean, obviously, if you don't have that, there are other ways to prove that you still have a digital copy. It was dated so and so. I sent the email on such and such date to my friend. Obviously, I wrote this. I sent it to him. All of that sort of process. But if you had a registration, it's just easier to say, look, the registration date is is this. And this is before the date that he published his book. So copyright registration, the point is that copyright registration is a helpful process but not a necessary process.
But if 2 people have the same copy, because one guy copied father, but the second person who copied got registered copyright, he has not got it.
No. Because copyright registration, good question, because copyright registration is not, when they are doing the registration, they are not looking to see, have you copied something from somewhere else? Because you could, for example, take something from somebody else's book and just send it off, claiming it is yours. The copyright board is not going to, there's no way for it to know who has written what in the entire world. They just don't know, right? They don't check. They simply take it on face value. Say, okay, you're filing a copyright? Okay. Here's your registration. So it's not conclusive to say whose work it is. It's simply a date that it got registered. That's all. Yeah. Again, registration is not as important as when did you create that work, right? Registration is helpful if you are going to court and you are trying to show that it was registered on such and such date, that was before something else came out and all of that. But yeah, and that now starts to go into fraud and things like that, right? But the basic point is, if you have written something, it is yours, the date that you have written it. I may have written 3 paragraphs of a book, I have copyright over those 3 paragraphs. If those exact 3 paragraphs are used somewhere else, in somebody else's book, and the rest of the book is completely different, I can still claim copyright infringement at least over those 3 paragraphs. Now, what is the damage to me because 3 paragraphs are the same? That you have to prove. What are your damages? How has it harmed you? Okay? But it just becomes more complicated to demonstrate to the court how can you show that you wrote it first? But that's a question of evidence, right? Of being able to demonstrate it.
Can I just interrupt for a second? See, copyright only protects the expression of ideas, not the idea itself. So, if two expressions may be same, obviously one copy from the other, which is different from in many lab exercises or many fields. You create an idea, you actually write down many, right? So that later on there'll be challenges and must be invented. Okay, so that is not copyright protection. That is more to establish you invented before somebody else did. So copyright essentially only protects the expression of idea, not the idea. So there's some distinction there. Putting the date and all those things. You simply establish I came up with the idea. Copyright doesn't protect ideas, it only protects the expression of ideas. I think there's some distinction. Huh?
Yeah, no, exactly right. So that's right. So copyright protects the expression of the idea, and a patent protects the idea itself. And to get a patent, obviously, you don't have to have a working model or a working prototype. You can just have the idea of your invention. Obviously, the invention has to be new and unique. So again, that cannot be a copy of something else that already exists, or a new application is also patentable. A new application of the same idea. But the point is, for our purposes, again, computer programs can also be copyrightable, and in the context of the internet, obviously, the relevance of going to internet era challenges, right? What is the relevance of copyright in the context of the digital world or in the context of the cyberspace? What do you guys think? I mean, why? Can you think of why copyright or having copyright or being able to claim copyright is relevant in the internet context? How is it different from copyright in the non-digital world? Okay, well, there's a slight distinction there in the sense, a good story, I didn't know about the story, but you're talking about patents, right? Patents, again, are jurisdictional. We talked about jurisdiction before. So if you go, in India, I can get a patent. The Indian Patent Office, Patent and Trademark Office, can only grant me a patent for India. The US Patent and Trademark Office provides a patent for the US, right? So if I want a patent in the US, you're right, even now I have to file I don't have to physically go there, but I have to file with the US Patent Office. Okay. But when you're talking about copyrights and the internet, the distinction is that right now dissemination of ideas that are put into some form has just become easier, right? When you talk about copyrights in the old context, the non-digital context, yes, you had to actually copy a book, have multiple copies of a book published. Then the next set was when you had CDs. You can have, I don't know how many of you remember pirated CDs. You could get pirated CDs of movies, right? Instead of going to a theater and watching it, you can get a pirated CD for 1/10 of the price, and you can go watch it. Quality would be terrible, but you can still go do that, right? So that is, again, that made it easier because you could load a whole movie onto a CD. That is piracy, right? Movies, again, expression of an idea, are copyright. They're protected by copyright. But the producer, the director, the producer of the movie is the one who has the copyright over the movie, right? And if somebody burns a CD after having watched it on the theater using a camera, they film it and burn it on a CD, they, under copyright law, they don't have the right to A, even record it, but B, to then burn it on a CD and then sell it on the streets for 10 rupees. Move on to the next stage, YouTube or Facebook or Meta, whatever, right? I have certainly tried to look for a movie on Google, and if it's available for free, why not watch it for free, right? Now, increasingly, and so there used to be a time when you could go watch all these pirated movies. There would be all of these file sharing websites, right, where you can download movies from. Same thing, instead of burning a CD, it was hosted on the cloud or hosted on somebody's server, right? But increasingly now you don't find that. You want to watch a movie, pay 199 to whoever, JioCinema or Netflix or Amazon Prime or wherever it is available, but increasingly you can't find that. You have to go to one of these OTT providers, right? Why? Because increasingly the enforcement of copyright has become stricter. And that, again, it's copyright. Movies are an expression of an idea or of somebody, and that, if without consent, it cannot be distributed or published by others. So, because that is increasingly enforced, it's harder to find things online which you can just download and watch for free without permission from the producer. But similarly, think about Instagram Reels or other modes of social media, right, where people put out contents. There are all these YouTube content creators, right? The content that they create, they have copyright over, and they get paid royalty based on how many views they have and so on and so forth, right? So the forms of copyright have expanded. The forms in which, manners in which you can get copyright and disseminate your information has expanded significantly. The other context in the online, the other challenge in the online context is where the copyright piracy comes from, or can be outside of the country, right? So, because things are on the internet now, you can access any information anywhere. Anybody could copy information that you have put online, copy it somewhere else and disseminate it somewhere else without your permission. And that may be within the country, it may be outside of the country. The platforms on which your copyrighted information exists may be outside of the country. So YouTube may have its servers outside of the country, you upload information there, somebody else's copies that, puts it out somewhere, right? So all of the ways in which the media disseminates doesn't care about borders, physical country borders anymore. Okay, so just talking about an example of these intermediaries, right? Platforms, internet service providers and other platforms on the internet where you can upload your content. And that includes research papers, right? There are places where obviously you can upload your research paper. You want the research community to know about your papers, so you can upload it, but that could be misused by others. Without your permission, they could be using it in a book, for example, in creating their own book. We'll get back to fair dealing, but before that, there was this older case from the 80s in India called Supercassettes versus MySpace. I don't know if any of you remember this platform called MySpace, but it was one of these early services similar to Facebook, where you could, or peer-to-peer sharing site, right, where you can upload content and others could access your content and download it and read it and so on. Supercassettes also I don't think anymore exists, but they were a company that produced music for movies and so on, right? Supercassettes Industries Limited. And they complained that MySpace was hosting material that they owned copyright over. So, music from movies that they had bought the copyright from the producer. I mean, we all know Bollywood music is popular, or Tamil music is popular, and they, super cassettes used to put compilation of this music into a cassette, right, or into a tape. But that was being uploaded by people onto MySpace, and then anybody could just download it. You don't need to go buy a cassette anymore. So they filed suit against MySpace, and even though MySpace was not the platform that was doing this uploading, right? MySpace was just a platform. You can upload whatever you want into it. And the court said, yes, MySpace is responsible. The court said MySpace is responsible for allowing the upload of material which people don't have copyright over. Now you are back to being Supreme Court judges. Does that make sense? What do you think? How many of you agree with what Super Cassette says? And MySpace on the other hand. So Super Cassette is saying MySpace is allowing copyrighted material to be uploaded onto their own website. They have responsibility for that. They should take responsibility for that. That's their business model. And so they're allowing illegal activities to occur, because these people who are uploading stuff are violating my Super Cassette's copyright. MySpace on the other hand is saying, I'm not in the business of monitoring who is uploading what. I simply provide a platform. That's all I do. My whole business model is, you're right, I simply provide a platform. I'm not the police. You have a problem, go to the police. File a lawsuit, go to court, file a lawsuit against the person who uploaded it. Okay, so Supreme Court judges. Okay, let's make this a little more interesting. This half is you are the lawyers for Super Cassettes, and you guys are the lawyers for MySpace. What would you say to support your case for Super Cassettes?
The shopkeepers cannot continually monitor what I'm using the net for. MySpace has just provided the platform where you can upload any information. Those information can be of any sort. So it's the responsibility of the uploader and the responsibility of the users that they should be hold responsible for them. And the platform holders are just giving the opportunity to, they are enabling the users. They are not recommending anyone to they are just enabling the users. So it's not, MySpace is not responsible.
Okay, and okay, so what if the material that is starting to be uploaded is very violent things about, people are uploading things about some murders that are occurring, taking shots of that, uploading it. You can think of all kinds of violent and illegal things that are occurring that people are uploading. Right? Is that okay then? Should there be a limit on what you can upload, what you can't upload, or extending that logic, anything is fine, right? Okay, so if illegal content cannot be uploaded, now do you have to make a distinction between what kinds of illegal content and what kinds of illegal content cannot be uploaded and what can be uploaded? Because that's what you're saying, basically violation of copyright is also illegal, but uploading stuff like pornography or violent acts and all of that, maybe that's also illegal. So then how do you draw a distinction between what illegal things to allow and what illegal things to not allow? Okay, so we can keep carrying on this conversation, right? The idea wasn't to have the entire discussion, but to give you an idea that this is not a black or white situation. It's all gray, right? You can argue on both sides. All of it depends a lot on the facts, exactly what's going on. In this particular case, the court held that MySpace is in fact responsible for the content that is being uploaded. But hold on, the story doesn't end there. We'll see how that changes. Okay, so under the Information Technology Act, we go back, we'll talk a little bit about intermediary responsibility again. Something called the Safe Harbor Clause was introduced as Section 79. So this principle comes from US law. And what the Safe Harbor Clause under Section 79 says is an intermediary shall not be liable for any third-party information, data or communication link made available or hosted by him, subject to certain things. So effectively, they had to bring in a law to say, no, you're not responsible. So I go on to say, subject to the following. What do you think those restrictions could be? So if you are now, let's say you are running a platform. You are the CEO of Facebook. You're Mark Zuckerberg. All of you are Mark Zuckerbergs. You won't be sitting in this class if you were. But let's imagine you are Mark Zuckerberg now, and you are an intermediary, right? Anyone can post anything on Facebook. Anybody else can read it. And the law in India says an intermediary shall not be liable for any third-party information, right? Whatever they post, or data or communication link, meaning links to other websites, right? Which is hosted by him or her, subject to the following. Subject to the following means except for such and such case, or as long as you do such and such things. What do you think some of those restrictions? So it's basically placing a restriction. Yes, you're not liable. I cannot sue Facebook for saying, oh, that guy posted something that is disparaging me. That is saying that, oh, Prakash taught a terrible course. I didn't understand one word of what he said. He should be shot. Somebody post that on Facebook. One of you post that on Facebook after you go back home today, right? Facebook relies on this and says, I don't care. You can say whatever you want about whoever you want. Not my problem. Except for what? Should there be any restrictions on this rule that there should be no responsibility for the intermediary? Intermediary in this is the platform, right? The platform where you post stuff, content.
I think if it is reported by people, right, like the Facebook and Instagram give us options to report any ad or any content. So I think if it is reported by many people, like 10 or 12 people, in that case they can look into the content, whether it is actually violent or disparaging or not, and then they can take down the content. I think that should be the exception.
Yeah. So that's certainly one situation where you could do that, right? That makes sense. That could be one restriction. As long as you, intermediary, when you get certain information, that you look into that information, and if it is illegal content or violent in some particular manner or is obviously insightful, it's trying to incite violence, right? Then you could take it down. Then you have to take it down. So you could put in a process, and that's basically what the law says, right? The law says, yes, as long as they follow a procedure for takedown, what are called takedown notices, as long as they follow that process, and it gives the opportunity for people to object to something, and it does. And the way you mention it is as long as 10 or 12 people object. Well, how do you decide whether 10 or 12 people or 5 or 6 people or 100 or 200 people, So instead what the law says is, as long as it is illegal, the content is illegal, and what could be illegal content, it's illegal under some other law, right? Obviously, for example, pornography is illegal. So if you see something like that and you send a notice, they have to take it down, right? Or if it violates copyright, so you have to send them material saying, this was my, in the context of Facebook, this was my painting, right? And I have copyright over this painting. This is the evidence to show, and here's where copyright registration becomes helpful again. This is evidence to show that I have copyright over this painting, but somebody else posted that on Facebook, and now the whole world has seen my painting. Nobody now would want to buy my painting for, 10 crores. So if you send them a takedown notice that has those details of how you have copyright, how the copyright was violated, and then they have to follow, and if they do their due diligence and reasonably believe that, okay, yeah, he seems to have shown that this person has copyright, then they have to take down that post. Okay. What the government has further done is introduce something called Intermediary Guidelines and Digital Media Ethics Code. It was introduced in 2011, and then again a new one was introduced in 2021. And that places rules on all these social media intermediaries of various kinds. It says you have to have your privacy policy posted and visible to every user. So there should be some link where you can go and access their privacy policy without having to dig too much. You can't post harmful content. You have to take down within 36 hours of receipt of a court order, right? So that's the other requirement, or from designated government agencies. So there are government agencies which have the power to block content. Now again, as you know, oftentimes you will see when there was violence in Jammu and Kashmir, you would see the internet is down or Facebook is not accessible. All of that the government does through this by saying you cannot allow Facebook they issue an order to Facebook saying shut down your services in this part of the country. And they have the right to do that for national security and other reasons. Is that a violation of our freedoms? If you are in Jammu Kashmir, yes it is. But again, remember, there are legitimate ways. If it's legitimate, if it's proportionate to what you're trying to achieve, then it is permissible. Okay, and then there are some additional notifies. There's another agency that you have to notify within 72 hours if there are security incidents, cybersecurity incidents, meaning if there's a hack. Right? So there are rules around all of that. And there are additional rules for what are called significant social media intermediaries, meaning social media intermediaries that have over 5 million users and so on. So YouTube, Facebook, and all those guys. Okay, let's talk about, I won't talk about that case, but let's maybe talk about this case. Actually, you know what, I'm going to skip this and talk about, and maybe we'll come back to this after we do this exercise, because I think everyone's energy is probably fading a little bit. It's 4:30. That tea has long been forgotten. Here's an exercise. And this this introduces a few elements of AI now. Okay. How many of you know the picture in the middle? Yeah, that hand shot up very quickly. Why? Yes, Vincent van Gogh's Starry Night, very famous painting. If you had the original of this, again, you wouldn't be sitting here, you would be a multimillionaire. But this is a reproduction. Obviously, this is just an image. So again, just a very, very famous painting. And this is Mr. Sani. Mr. Sani is a nobody like you and me, just a regular guy who took a picture from his house balcony. The sun is setting there, you can see parts of his house. And then what he did was, he put the original photograph that he took on the left extreme and an image of Vincent van Gogh's Starry Night and inputted those into an AI model called Raghav. That's the name of the model. The model itself is called Raghav. And he said, okay, create the output. I mean, it was basically what the input was, what can you come up with? Raghav's job was to, merge two images and so on. So he put these two images in, and it came out with this output, the work. This is the work. Okay? Now, we know from copyright that Vincent van Gogh had original copyright over his painting. We know that Mr. Sani has copyright over his photograph. He has now developed a model, and he inputted this into the model, and the model gave him this work. Who has copyright over the work? Yeah? Sorry? Sani's original photograph he has copyright over, but over the final work, you're saying he has copyright over the final work as well? Okay, but he didn't make the final work. Any other thoughts? Sorry, the developers of the model? Could be, but they didn't provide the input of the original photograph or of the Starry Night. Basically, they had nothing to do with the output. The idea is Sani's, but remember what Professor Dasarathy mentioned. Ideas are not copyrightable. It's the expression of the idea. Sure, he had an idea. The picture is an expression of his idea. Good point. But he has copyright only over the original photograph originally, right? So that's the expression of his idea of taking a picture with the sun and my house, and he did all that. But then that got processed, it got modified. And he didn't do the modification. I mean, he gave the instructions for the modification to be done. But he didn't do the modification. Any other thoughts? Okay, so we leave that one there. That's an example of new kinds of challenges that are coming up in copyright, right? What do we do when AI is involved? Who has copyright over output that uses AI? Is it the person who provides the input, the prompt? As it's when you're using AI models, you use a prompt. So is it the person who's providing the prompt? Is it the developers of the AI model? Or is it the AI model itself? Can the AI model be someone who has copyright over it, or something that has copyright over its work? Because really it's the AI model that did the job. Okay, so we'll come back to that, but before that, I did want to touch upon one other thing as it relates to copyright, because many of you are at a university or a college right now, which is the issue of fair use or fair dealing. So we talked about how you cannot just copy somebody else's work, right? In the university context, plagiarism, you cannot just copy somebody else's work and pass it off as yours. But what about lecture notes, for example? There are textbooks, there are colleges and schools which compile lecture notes from different books, put them into a neat little package, and hand it out to you as students. Here are all a compilation of lecture notes. What about your making a photocopy of a book for your own purposes? Again, a professor says, all of you, read chapter 20 of a book, and there's 40 students. The library has 2 copies. So he's going to go make photocopies, right? Go have photocopies made so he can distribute to everybody, and says, read this chapter before you come to class tomorrow. Copyright violation?
It is a copyright violation. It is. Prima facie it is.
Yep. Yeah. On the face of it, it is, right? It is a copyright violation because it is copying somebody else's work without their permission. We didn't go get the author's permission. But
then again, you talked about fair use. So if it is used for educational purposes, it is being used fairly. Therefore, the students can copy.
Correct.
to photocopy the books and distribute it to the students.
Exactly.
Yes, so I think in that case.
Exactly right. So it is fair use because there are exceptions to copyright laws that say if it is for things like academic use, obviously for your own personal use, right? If you buy a 300-page textbook, and I'm coming on this trip from Bangalore to Trichy, I only want to read chapter 1, so I go have chapter 1 photocopied so that I can take it on my flight to Trichy. I don't want to carry the whole book. That is fair use. It's for my own personal purposes. I'm not making 100 copies and trying to sell it for commercial gain, right? That's fair use. Same way, at university for research purposes, fair use. You can make multiple copies as long as it is for educational purposes, for research purposes, right? So that's called fair use. And exactly right, there was a case in Delhi where they did exactly this. On the college premises, there was a photocopying shop, and they would allow students to go photocopy books, compile them into different chapters into sort of one bound copy, hand it over to students, and all of that was declared to be fair use because it's for educational purposes, for research purposes. Okay, let's talk about some of these new issues. So we talked about copyright over AI generated work, and this was that Raghav AI case. So interestingly, in this was in fact a real case. The Mr. Sani tried to copyright the final output, saying it's mostly my work, right? And the Indian Copyright Board said yes. It's in fact, sorry, the Indian Copyright Board said yes, it is copyrightable, but not in Mr. Sani's name, but in the name of the AI, Raghav. Raghav AI got the copyright. And then they woke up and then they tried to take it back. They said, no, actually we made a mistake, and they sent a notice to Mr. Sani saying we are revoking the copyright. And then Mr. Sani now has gone to court saying you don't have the power to revoke anything. Once you've granted the copyright, you've granted the copyright. Under law, Mr. Sani is arguing, you don't have the power to take back a copyright that you've given. So that is still being discussed in courts. It's interesting. Mr. Sani also went to the US and said in the US, he went to the US Copyright Office and said, my model, Raghav, has created this. Give Raghav the copyright over this work. The US Copyright Office said no, because there is not enough human contribution to the output. They said that just him taking the input and putting it into this model. Now it's a different question of whether he has copyright over the model. That's a separate question. This is only about a question of this picture, right? So the US Copyright Office has basically said an AI model itself cannot get a copyright. There has to be enough adequate human involvement. And they said there is not adequate or extensive or sufficient human involvement in this output. So this is still an evolving area, right? Many other countries have taken a similar approach of saying there's got to be some human involvement. Just a machine or a program or a code throwing out some output. Copyright only attaches to a natural person, a human. It does not attach to machines. Machines cannot own copyright, is the position that most countries have taken. There are obviously questions of, well, where a human and the machine are doing work together, who owns the copyright? Does the human own some copyright? What does some copyright mean? How much involvement is enough involvement? So lots of questions around all of that, right? Again, we won't go into a lot of detail, but just to give you a sense, to train you've probably all heard of artificial intelligence, large language models like ChatGPT. That's what it is, a large language model. And ChatGPT uses, or to train itself, to train the model, it has terabytes and terabytes of information, right? It has lots of information that it then uses to answer your question. But where does it get all that information from? So there are lots of cases that have been filed in the US courts by publishers such as New York Times and others who have their materials, right, that are available online. They have their materials on their app, they have their materials on their website, so online on the internet, and they are arguing that all of these developers of large language models like ChatGPT, OpenAI, which is the company that developed it, they have stolen our copyrighted material. They've stolen our material because their models scrape data. They basically pull data from all these websites and all these articles, right? What does New York Times have? New York Times, a newspaper, just like newspapers here, Indian Express. What does Indian Express have? When it publishes its newspaper, Indian Express has copyright over that newspaper. It has the same copyright over its content when it's hosted online. You go to indianexpress.com, the way they show the content there, they have copyright over that content. Same way, what New York Times, they have a physical paper, they have an online paper, and they are saying all of this online paper, because they've been around for a long time, they have all of this information archived. And they are saying that these AI models are taking all that copyrighted data and they took it without our permission. So all these models have learned from other people's data, copyrighted material. It's the same thing, it's not just New York Times, a number of other media companies have done that, a number of other individuals who have posted material online have filed suit saying the same thing. You, without my permission, took my data to train your model. All those cases are still ongoing. But obviously, in what some of these companies have done is put firewalls, increase their security so that data scraping cannot occur. And some others have already entered into arrangements with OpenAI and other AI developing models to license out their data. Okay, and then some of the other new issues, I think you'll be talking about deepfakes later, but here's an example of a case in 2023. How many of you recognize Anil Kapoor? Actor, Hindi movie actor. Okay. Okay, so Anil Kapoor in 2023 filed a case against this company called Simply Life and a number of others. And what he complained about was a lot of what we see actually when you go on Facebook or YouTube or Instagram and all of that. He was, or even WhatsApp actually, he was complaining that the Simply Life and other people were creating GIFs and memes using his image. So I'm sure you probably sent some Rajnikant memes and Rajnikant, you can create Rajnikant GIFs and things like that, right? Rajnikant has never given permission, probably, never given permission to anybody to allow them to create memes and GIFs and all of that, right? Using his face. That's what Anil Kapoor said. I'm a famous actor. This company is creating GIFs and memes and putting it on t-shirts and allowing people to create memes and send it online and all of that, and that is a violation of my privacy. And the court said yes, and then obviously he said it's a violation of his copyright because of the way in which he stands or he poses and in the way in which he acts and all of that were created into memes. That's a violation of his privacy and a violation of his copyright. And memes that use his voice, he said, I have copyright over my voice. You do. So that's examples of how in the online digital world there could be copyright infringement continuing. Some other developments, and I'll stop with that and ask for questions. But some other developments, for example, more recently are things like dark patterns, and there are guidelines that have been put out under the Consumer Protection Act. So what are dark patterns? Are things like If you go on to if you're trying to book an airline ticket, let's say, right, and you see a price, and you click on it, it takes you through the whole process, and suddenly the price has changed. I don't know if any of you have experienced that. I certainly have. Or what's called bait and switch. They say, okay, it shows you some product, Flipkart or something, right? Shows you some product. A pen looks very nice, 100 rupees. Oh, that's branded pen for 100 rupees. Sure. Click. Not available. Instead, do you want to buy this pen, 200 rupees? And you've already invested 5 minutes. You're like, oh, whatever, just buy, right? That's bait and switch. So that is modes of advertising, modes of misrepresentation, which has wasted your time. You are expecting something else, but the ultimate outcome is something else. Swiggy regularly adds, I think 1 rupee, it's 1 rupee for some fund. It's always clicked, nobody cares. You pay that 1 rupee because it's some kid fund or social fund or whatever fund. Where does it really go? God alone knows. So all of those are, did you consent to it? Yes, that button is ticked and you have the ability to untick it. But did you actually want to contribute to that? No, right? Because it's not, you didn't ask for adding that additional contribution to anything. So all of those methods or means of unfair advertising in the online context, right, are or pop-ups that come up on your website so regularly, right? You can have a pop-up blocker and all of that, but there are still pop-ups that come that seem to keep coming again and again and again and again. And even after you click no, it pops up again. So there are guidelines that the government has come out with that imposes restrictions on platforms and companies to cut down on all those practices, to make sure that what you see is what you buy online, for example. What you want is what you get. So those are other developments in the context of changing nature of the internet. Okay, so I will stop with that. And ask if you all have any questions. Otherwise, tomorrow we will talk about, at least in the lecture that I will give, we will talk about cyber crimes and some cyber torts, which is harm that can be suffered using the internet, and how you can file cases and so on and so forth. But any questions otherwise for today? Yeah. Yeah, so you can go to the Consumer Protection Bureau or Consumer Board, right? Right now, these are still, these guidelines, actually I do think they have come into force. So you can use these guidelines and you can go to the Consumer Protection Board. And often filing cases, because these are typically low value cases, right? So you can typically go just check online. Online, the Consumer Protection Board has its own page. You can file a complaint online, and all of the hearing and everything, you upload all your documents, and the case is often all decided online itself. You don't have to do much. But that's one way. The other way is many of these industries are required to have what are called ombudsperson or ombudsmen, again, to whom you can file complaints. Right. Exactly. So banking is the most prominent, where by law they're all required to have ombudsmen, and you can file a complaint with the ombudsman. The ombudsman is supposed to be an independent person who is supposed to look into your complaint so that you don't have to end up going to court. But not all sectors have the requirement to have an ombudsperson. The other is you can often go to industry organizations, have their own independent ombudsperson, but typically the best way is to, obviously just raise a complaint to the company, And if that is not resolved, then go to consumer court. Okay, any other questions? Okay, thank you everyone. Have a good evening.